Welcome to SpringLaw's 2019 SpringForward Legal Updates Webinar Series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit SpringLaw at www.springlaw.ca. And now to our presenters.
Good morning and welcome to our SpringForward Legal Updates webinar today. We're excited. We have a good number of people attending today, so this must be a topic that seems to resonate with everyone. Today's topic is top 10 mistakes to avoid when hiring your first employee, or ZZZ if you are already in the employer status category already. My name is Lisa Stam. I'm a lawyer at Spring Law, and joining me today is Marnie Baizley. Together, we are one of the 4 lawyers at Spring Law, a virtual law firm here in Ontario that specializes in employment and contracts law. We especially love working with tech companies and startups and being in that tech space, in part because we're all particularly tech savvy, especially for a lawyer, so maybe it's all relative, but we have a real affinity for figuring out technology in the workplace. So we're delighted that there seems to be a lot of tech people on our call today, our webinar today. During the webinar, feel free to ask any questions you might have. Just put it into the chat box and we'll try and get to it if we can. If we run out of time, we only have 30 minutes. We want to get people back to their busy day. Just email us afterwards and we'll give you a hand after. Finally, if you would like more information about our law firm, here is the inevitable pitch. Just go to our website. Feel free to check out our weekly award-winning blog and sign up for our monthly newsletters. Look into our subscription program, which is an innovative program, especially for people who are smaller employers. You know, that 1 to 20 spot where you need all the documents up front. But you need to really stagger out the budget and deal with the hiring and the pain points of being a new employer. We have an ebook for people who might have been recently terminated. That might be a good resource for employers as well, small employers. And again, if you have any questions, just reach out to us and we're happy to help out. Okay, so let's jump in. Presented today by Baizley and Marnie Baizley and myself, not Baizley. Our roadmap today. So we're going to talk about the top 10 mistakes that we want you to avoid. Misclassifying your worker is number 1. Calling everyone a contractor when they're probably an employee, and where does a freelancer fit in that? And there's all kinds of other words that get thrown around. Dependent contractor is another one. We're going to go through all that. We're going to talk through the CRA and statutory requirements, which I will confess up front that we had our office manager help us out with because she does all our payroll stuff, and so you're going to get good information on that topic. How not to muck up your employment contract and the recruitment process, avoiding the loosey-goosiness of remote working rules. A big mistake is being cynical about disability issues. And failing to perform performance issues before they blow up, and then the IP and non-compete, non-solicit type stuff. Finally, firing your friends and family badly. We will get to that as mistake number 10 to avoid. Okay, I'm going to hand it over to Marnie. She's going to talk about the first topic.
Thanks, Lisa. Good morning, everyone. Thanks for joining us. Full disclosure, I have to say I've never been called tech savvy before, but I like it. Those in my inner circle might chuckle at that, but I work very hard at it to keep up with the team at Spring Law, and Marnie as tech savvy, I really like the sound of that. So let's jump into employees and independent contractors. I'll give you a brief snapshot of what these two animals are, and the dependent contractor animal, the third sort of mushy world in between. I'll talk about that, and then I'm going to talk for a couple of minutes about why that matters and why that matters to folks who are in business and hiring their first workers. So starting with employees, so independent contractors, employees, and freelancers, they're often a blend of workers, and they're either employed, actually, Lisa, you want to take me to the next slide, sorry. I'm going to jump in talking about employees.
Perfect.
So employees. Employees enjoy the benefits and protections under the Employment Standards Act, and those would be things like minimum wage and overtime pay and various leaves like personal emergency leave, parental leave, sick leave. They're generally paid wages with payroll deductions like CPP, EI, and income tax, where those deductions always occur. But they are also often compensated by incentive compensation plans or bonus plans that are tied to company performance. So a real link to the company and employer. And they have a steady wage that's usually the same amount regardless of the profitability of the business, subject to the incentive compensation comment I just made. They're expected to devote, usually expected to devote their full time and attention to the employer unless there's some other arrangement that's been made. And in fact, lots of employment agreements have what we call a full time and attention clause to make sure that the organization, the employer, is in fact getting the full time and attention of this individual. These people are provided with tools and equipment to do their job, so laptop, computer in the office equipment, or perhaps a vehicle if they're a salesperson, smartphone, all the tool, a list, a customer list, prospective customer list, and they're sent off as employees to go do their work for the company. So they are somewhat constrained in how they carry out their duties by the direction of the employer. So they take their instructions, and they have the performance reviews, and the whole plan is set by the employer. So let's look at independent contractors. By contrast, so these folks don't have the protections under the Employment Standards Act. They typically, how they're structured, they invoice the company for their work, and they make their own remissions to the government. So they handle income tax and HST on their own. They assume the risk for their own profit or loss. So when business is good and they're busy, they generate more income, and when times are slow, they generate less income. So they don't have that same income security as employees. They can provide services to multiple clients at one time. So this is the one big benefit. They can be out and about and servicing various clients as long as they fulfill the agreements that they have with the company, which hopefully would be detailed in an agreement so everyone understands the expectations in a service agreement or consulting agreement or independent contractor agreement, whatever the actual document is called. They provide their own tools and equipment, so their own vehicle, typically their own computer equipment, office equipment, smartphone, etc. And they have the flexibility to design their own work arrangements. So their own hours, their own schedule. They can hire their own workers, whether they hire as employees or subcontractors. And they very much have control over the way they provide their services. And then the mushy world in between, as Lisa called it, is folks can land in a dependent contractor classification. And for those of you who are US-based companies with Canadian operations, this is a uniquely Canadian concept, dependent contractors. And just in a nutshell, these folks can be entitled to notice, which can be significant and expensive, on termination. So there's that middle category to be aware of. They're not necessarily an employee for sure, or an independent contractor. On the other end of the spectrum, there is this middle ground called a dependent contractor. Very briefly, just why does this matter? At the front end of an agreement, you should really take a step back and look at who this individual is, what you want them to, what services that you want them to provide for the company, do an analysis, and it's a fairly detailed analysis. We go and we look at various factors and come out on the other end and say this person looks more like an employee or an independent contractor or a dependent contractor, and it may be that the company says, you know what, they actually probably look like an employee, we're setting it up as an independent contractor, and we're prepared to take the risk that this person may be misclassified at the end of the relationship, but it's an employee who's relatively young. You know, they will reemploy quickly, which is key, and therefore their notice entitlements may be shorter and therefore less expensive, and we're going to take that risk. We want to set it up that way, so that's fine. It's important to go through the analysis and really look at the person, because an employee in a different circumstance could end up being a very expensive issue on termination, and so it's really worth looking at the person and the role they're going to be playing before you set up the agreement.
People tend to take the position that they're the employee at the end of an independent contractor relationship where they're now, really pissed at the company for whatever reason, and they will often then take the position that they're actually an employee, and when they realize they're not entitled to any termination pay. So it tends to emerge as an issue at the end of a relationship that maybe hasn't gone well. So it's good to just really document it nicely at the front. Marnie, I believe I cut you off, and I didn't mean to do that. Was there anything else you wanted to add to this topic?
No. One final point is it really comes down to the substance of the relationship. So if you paper it one way, you can't rely that 100% this will be an independent contractor, because we talked about it and we papered it that way and it worked well for both of us at the front end. As Lisa said, if things go awry at the end, a court or a fact finder will actually really look at, what is this animal? If it walks like a duck, talks like a duck, it is a duck. So don't be too reliant on the document, because a different determination could be made. And the onus is on the employee to prove that. If they're trying to prove they're an employee, the onus is on them, but there really is an in-depth look at what the nature of the relationship was. Yeah,
that's a good point, actually, that you can't just call it something, and that won't be the final answer on this. One last thing that we didn't include in the slide, but that is probably important in the startup space in particular, the default position around who owns the content. If you're an employee, and there's just a regular employment contract in place, the work that you do in the course of your usual employment will be owned by the company. If you're an independent contractor, it's a much more of an uphill battle. The default will be that the contractor probably owns their own content, because unless there's a contract or some sort of agreement in place, because the idea is that you're pulling in a specialist to work on this project, so they probably have all this expertise. An employee is just a servant to the business, and everything belongs to the employer. So it's just something to keep in mind if you're having someone working on something particularly sensitive, paper it like crazy with some sort of confidentiality agreement, but there's a greater safety if they're actually an employee instead. Okay, let's keep moving along. We want to make sure we only take up 30 minutes, which we'll see if we can do this. So we'll try and issue spot more than anything else as we go along. So mistake number 2 is missing CRA and statutory requirements, and it is a bit of a laundry list to keep track of, especially if you're busy running your business and creating what you're creating instead. And so I can tell you the CRA has some great materials on this. There's a guide for employers. The Ministry of Labor has some great materials on this as well. But here's just a checklist of, opening the account with CRA for your payroll, the different forms to fill out, deciding whether or not you are obligated to get some workers' comp for your employees. Usually not at the beginning if it's straight office. If you're, doing oil drilling somewhere, then yes, you will. So it'll depend on the nature of your business. There's some posting requirements. You need to distribute the Fair at Work Ontario poster. It sometimes depends who's the premier of our province. Some of these things do switch up and down depending on what the government's latest comments are on the Employment Standards Act. But for now, you need to distribute these posters. And then there's different occupational health and safety requirements. So we're issue spotting on this slide for you so that you get a sense of some of the things that you need to take care of. All right, mucking up the employment contract. Marnie.
So the main point of this slide is if you use templates, you already have an employment contract, make sure it's up to date. There's lots of case law on employment contracts and termination provisions in particular, and make sure they're up to date and valid and enforceable. And really that's the biggest thing you want to do here is check your contracts. Don't just use templates for all employees, and make sure the termination provision applies to the individual, their level of seniority, their level of expertise, and really tailor the provision, and particularly if it's not a frontline employee. The frontline employees, again, as long as your termination provision is up to date and valid, that's the kind of contract that can be reused. But when you have your more mid-level and senior employees, really take a look at who they are, particularly with respect to the termination provision, and also with respect to post-employment rights and obligations, around confidentiality, the restrictive covenants like the non-solicitation of clients, customers, or employees. Really look at the front end who this person is and what you need to protect. What are your legitimate business interests? And rather than just using your template that says 2 years and you can't go anywhere in this broad geographic area, here you go, sign off. That is very often going to be an unenforceable clause, and that's why you need to turn your mind to it and think about who's this person and this is what we're trying to protect. And they may come back and say, I'm entrepreneurial and there's this area of interest that I've been working on in my spare time, and if we were to part ways, I would like to pursue that. And the organization might say, that's fine, let's draft that in, and that's not what we're trying to protect here. And at the front end, both sides understand what's going to be the case on termination, and that really reduces acrimony and simplifies things on exit. So I know I've glossed over this slide quickly because I'm trying to catch us up a bit, but it's focus on the termination clause and focus on what you care about on departure. Signing before the first day and getting your ducks in a row with your agreement is also very important, and that's the same theme. Really think about who this is and what do we need to tweak in our template, or what do we need to ask our employment lawyer to put into the contract for this person, and look at them as each specific case.
Yeah, and if I can just add one comment, for most startups, the first or second or third employee, if all goes well, they could become your CTO one day, or your CFO as you grow and become big. So and the contract follows you through. So even if you are you're still small, you're in startup stage, you're in a co-working space, and you're full of great enthusiasm and ideas, slow down for the contract for your first handful of employees, because you never know if they're going to be a $500,000 exposure down the road because you've grown big enough that they're now an executive in your big company. It's hard. We face this every day with our clients who are just too busy building their thing, and so these first couple of hires are actually quite important to get the contracts right.
Okay, so mucking up recruitment is another important mistake to avoid. All stages of the employment relationship, right from the first job posting to interview process, to papering or reference checks and papering the employment agreement, and right through to the end of the employment relationship, that is all covered under the phrase employment under human rights legislation. So whoever's in HR or head of talent or wearing any kind of pseudo HR hat needs to be very mindful of human rights legislation and every touch point with employees or workers. And to be familiar with the concept of discrimination and the grounds of discrimination in the Human Rights Code. So people can't be treated differently based on all of the protected grounds in the Ontario Human Rights Code in Ontario. And so those grounds are, for example, disability, race, gender, age, sex, and there's 16 grounds that apply in employment. So familiarize yourselves with that and take a look at your recruitment materials. The Ontario Human Rights Commission has excellent resources. I think if you Google human rights at all stages in employment, there are really great materials for applying to a recruitment process and interview tips and things like that. And in terms of the job posting, it's a good idea or it's required that you identify that you're an employer that complies with the Accessibility for Ontarians with Disabilities Act, and you're an accessible workplace. And if there are any accommodation requests during the recruitment process, that you can certainly assist the employee, whether that means providing materials in a different format or picking up the phone and clarifying something for someone. That should be in your postings, and everybody should be aware of their obligation to make the process accessible for everyone.
If you're in startup phase, you probably don't have an HR department. You are the HR department. And so, to make it simple, just be mindful that your emails that you're sending out, or you're engaging in a chat with someone about maybe joining, coming on board, those emails are all part of this recruiting process. So, and if you decide not to give someone, yesterday, actually, I heard someone did not get a role, and they were actually told by the recruitment company that they needed someone with a longer runway. And I was shocked that a recruiting company would say that. In other words, he was too old for the job. So be careful of what you're putting either in writing, or if they're just not qualified or there's not a right fit that's not to do with discrimination. Go ahead, write that down. But your emails, the whole recruitment process is captured under the Human Rights Code. It's not. It doesn't all start once they are employed. It starts right from the beginning.
That needing a longer runway is very interesting. The euphemisms never cease to amaze me.
Yeah, I know. Yeah, it's crazy. Yeah. All right, Loosey-Goosey, remote working roles. So, lots of startups are working remote. We're a virtual firm, and we work remotely. Technology lets you all communicate very easily and readily. And so this is just going to be a growing reality. So we have an internal remote working policy that we use, and some of the topics that we include are requiring responsiveness and communications, just setting out expectations about when and where people can work, when they can meet with clients, where they can meet with clients. If you're now a larger company and you have a bricks and mortar place as well, then who's eligible to even work remotely? All these things should be clarified. If you don't get around to any remote working policy except for one single thing, it's all about protecting your digital assets. So really talking about digital security, having protocols around two-factor security, authentication protocols, and then more than anything, upon termination, just think ahead. If this person leaves, and especially if it's not an overly friendly departure, do you have all the passwords? Do you have access codes? Do you have hardware serial numbers, so that if they say, oh, I never got a $700 scanner from you, you can say, well, actually, here's a serial number. Let's take a look. Even something as simple as when they set up their remote office, have them take a picture. And that way, then you can see what equipment is there, and it's just some information for you to keep on hand. Okay, cynical about disability issues, mistake number 6 to avoid.
Okay, so as you'll see here, this is one of the busiest areas of employment law and probably one of the most complex. So if you have a worker who has said they have some kind of illness or disability, or if you ought to be aware that they're showing signs of symptoms of having a disability in the workplace, employers, organizations have an obligation to offer support and investigate and find out if this employee is okay and what supports they might need. So really the starting point is to give the employee the benefit of the doubt, even if this is the employee that always seems to have issues on a Friday or a Monday, or issues that arise whenever there's a constructive feedback provided, or just the malingering employee. Those are difficult situations, but you want to start with every employee from a good faith standpoint, and giving them the benefit of the doubt, and listening to them and trying to figure out what supports and resources you can suggest to them. And recognize that workplace stress and medical symptoms are very real. We're seeing a lot of that now, just the demands on the workforce. We're advising lots of employers on how to handle these difficult issues, these non-visible types of illnesses and disabilities. So really follow up, document your follow-ups, and again, offer those supports and resources, and document all the efforts that you make for these employees. And if this is a two-way street. We did a whole webinar on managing disabilities in the workplace. It's a two-way street in terms of what employers' obligations are and employee obligations, and they have an obligation to cooperate in the process and keep in touch and comply with whatever accommodation plans are in place. And if things start to derail, then this is where it becomes very complex. But there is a way to navigate these situations so that hopefully the employee can return to get the treatment they need and return to being a productive employee. Sometimes that's not the case, but it needs to be managed very carefully and documented very carefully.
Mm-hmm. And the other thing to just note in the startup space is often, it's your second or third employee, and it's a very tight and small team. So it's a huge problem if 1/3 of your workforce is off sick. And often it's someone that maybe you knew personally for a while, or you went to school with, or it's a relative. And that cynicism can come in because, you know, if they would just suck it up a bit more, or they always do this, they've always been like this. And you as owner, you just have to keep on going. There isn't time for a stress leave. So, you bear the brunt of it, and it can be very frustrating. The advice that we always give, especially to the owners of a startup, is you're not writing just for the eyes of this employee that is really driving you crazy. You're writing for the eyes of an adjudicator. So everything needs to just be this benefit of the doubt. Don't sound cynical. Don't talk about how they always are such a whiner, and really write in an objective, neutral, calm way so that you have great evidence, frankly. Otherwise, it's easy for employees to succeed on disability claims. It's a very busy area of our practice right now.
And another related point is, if you're documenting this internally and having internal conversations, this is me with a lawyer hat on now, be careful what you say about the situation, and be careful not to prejudge and draw conclusions in your internal documentation, because if it's not a communication to a lawyer, it's not going to be privileged, and it would be producible if this person filed a human rights complaint. Right. So be careful of what you say and what you put in writing.
Just pick up the phone and talk to your lawyer. You can vent to them. That's all privileged, but don't put it all in writing. Okay, mistake number 7, Marnie, failing to manage performance.
So failing to manage performance before things blow up. This is an important issue to be mindful of right from the get-go. Providing constructive criticism, frankly, feedback along the way to employees, and documenting it is really important. And having a system where you regularly review performance is really helpful, because when things do go south, you'll have had a system in place, and the employee's not going to feel like things are being papered and they're being targeted. And maybe they can turn around with some mentoring and extra direction. And this is all part of a performance review process. But whereas if matters are not documented, performance is not reviewed regularly, they may have some kind of inertia or paralysis when they suddenly start having meetings they have follow-up emails coming to them, and that's a very difficult circumstance to perform under. So in terms of maximizing your talent and having them be successful, managing performance is very important from that respect. But if you have an employee that's not going to work out, it's very difficult to terminate for cause if you have no record of the steps you've taken to help them perform better, and you need to have let them know that their job is on the line, their job's in jeopardy as a result of performance. So documenting, extremely important. We've got this write it down document in here a couple of times. And this getting ahead of the game and not waiting till emotions take over is very important, because just having a process in place and being able to, if you're wearing this HR hat, being able to sit with this person and get them back on track in a logical way, and be able to point to what you've done with them, for them along the way, and look, this just isn't working out, and you haven't kept your end of the bargain up. It's going to be a lot easier conversation with a documented process than when you're just pissed off because you're, as Lisa said, 3 people in this company and they're not pulling their weight. It's very hard to solve those issues when they get to that point, or when they've quote unquote blown up.
It also doesn't need to be a great big elaborate performance improvement plan pursuant to your protocol. It can simply be you go for a coffee with them, you have the conversation, and then you follow up with an email that says, just want to recap our coffee today for both our records. And you write down that's all you need to do. But these verbal coachings that we often run across, where the HR or usually not HR, if it's more of an owner operator without HR, and they make their own notes, but they don't share it with the employee. So it feels very self-serving, and it's tricky evidence. So it's important to just use email. Just flip a quick email recapping what they said, and there's your record. Okay, mistake number 8, giving away all your ideas, which I think most entrepreneurs would like to avoid. So restrictive covenants are the fancy word for your non-competes, your non-solicitations, your confidentiality section of the agreement, and possibly a policy. We tend to recommend that you hive out these components and make them a Schedule A to the employment contract, and have the employee sign off as a separate step, just to really reinforce how important it is, and then you can have it float through the employment relationship. enforcing a non-compete is not easy. Marnie already talked about it a bit, so I'm going to jump to the next slide, because I think the point is, if you want to protect your ideas and protect your company from this person who's working with you from going off and starting up a competitor, we live in a free market. I mean, the people are allowed to brainstorm new business ideas and go off and do it. Most entrepreneurs have done it themselves. They're probably at a big company, and in their final weeks or months, they were already plotting about this adventure that they're going to go on. So, you know, including this and having the clarity about what is going to be protected post-employment, and then following up. If someone, especially if they leave on bad terms, you know, bake it right into that termination letter that we want to remind you of these restrictions that are in your contract. Mistake number 9 is not protecting your ideas. We are not intellectual property specialists, so all we can say is identify what you want to protect. What is the unique thing that you've just created that you want to protect, whether it's a technological advancement or an engineering feat or a process or a creative work, whatever it is, the thing that you want to protect that's special and unique about your company. Hire an IP lawyer and protect it. I mean, there's just no way around it. It's a very, very complex area, and without IP protection, you lose your ideas, and that's the whole point of entrepreneurialism. Finally, mistake number 10, firing badly.
All right, firing friends and family badly. I mean, how awkward is having to fire a family member or a friend? Terminations are awkward enough, but when it's someone in your circle or inner circle, very difficult. So having that contract in place that I talked about earlier, very important, and you know, it makes it a termination much more seamless. If you can pull out the contract, figure out what the entitlement is, put it into a termination letter, attach a release if you're going to give them more than what's in their contract. Nice and clean, grab another person to be at the meeting, give them time to consider the termination package, go away and think about it. And when you're preparing the package, you know, who's this person? What's going to help them land on their feet again? Think about if you want to and can help them. You know, job leads, reference letter, you know, if you can afford to pay them for a certain period. Think about that. I mean, you're only required to do what you negotiated at the outset and what's in your employment agreement, but turn your mind to this person and what's going to make this this exit smoother, because it's going to, you know, these are never fun, and it's an awkward process. But having talking points for termination meetings set out in advance is critical, and we often help with any termination, but particularly messy or awkward ones. Help our clients to set that out and have a plan in place. And you don't have to get into a long, complicated discussion. You don't have to give reasons for a termination. If you're prepared, you can hand this letter and say, look, we regret this decision was necessary. Here's the documentation. We're going to do what we can to help you out. Take some time to think about it and let us know if you have any questions. And it should be a fairly seamless exercise. And again, with that contract in place, you can really eliminate acrimony and that would otherwise hurt employee morale, and a whole list of things that make terminations more messy. So there's a lot you can do to tee up a termination meeting so that it goes more smoothly.
Mm-hmm. That's firing. This should be a whole webinar on itself. Is firing. It's really where the most, this is what case law is all about. This is the most expensive moment in the relationship if it doesn't go well. So, you know, thinking through that termination provision is upfront in your employment contract is the best money you can spend on any sort of legal stuff, frankly. Okay, takeaways. Write shit down. Just write it down. Please just write it down. I don't know if we've conveyed the message strong enough throughout this webinar, but if you write it down, then it just is, it's more accurate, and you know, you can share it with the other side whenever you can, and it's transparency, it's process, it's not reinventing the wheel every time. You know, clearly employment contracts and policies, we cannot do an employment webinar without mentioning the policy word. Policies are part of all this because that is the rules of the workplace, and it lets you have the guideline for everyone to be on the same page about expectations. You know, hope for the best. The entrepreneur mindset, you know, the startup phase is so exciting, right? It's great ideas that are and building stuff. It's the creative process. It really is such an exciting time. And so the idea of planning for the worst is nobody wants to do that. But it's math. Just sit down and spend an hour thinking through the math of this and plan accordingly. And then the big one is when employees are leaving, just think through what you want to protect. Your ideas are important. Your digital assets are important. Your client lists, which are part of digital assets, typically are important. Who cares if they take a $200 piece of hardware? It's the data on that hardware that matters. So protecting your business when they leave is the other big takeaway for us to convey. Okay, we managed to hammer through our top 10 list in 35 minutes. I'm sorry, we're 5 minutes over. If you have any questions or any follow-up comments, any feedback, please feel free to contact any of our lawyers. I want to give a shout out to Janice Morris, our office manager, who did the slide on CRA and statutory obligations. She's our math guru internally and does all the statutory and CRA stuff. And if you have any questions, give any of us a call, including her. Sign up for any future updates if you like through the website for future talks. Our next what's our next webinar? Do you remember, Marnie, what the next one is?
Oh, you're putting me on the spot here.
I know. Sorry. The next one is on drug testing. What's the deal?
Good job.
Yes. So feel free to join us for that, especially if you're from the U.S. It's just very different in Canada with our much more robust privacy laws.
Hillary Page is our in-house expert on drug testing. She's doing that webinar.
Not our expert on drugs, but on drug testing. Just want to make that clear. But thank you very much for joining us today, and have a great day. Hope to see you there.